Hi guys, it's Kathy. I hope you're doing well. Oh, Donald, you'll be fine. You'll see. Everything's just fine. They're going to do that scan and you'll be fine. So, I have the case with the horse, emotional support pony. Although I didn't watch it, but I tried to scan through it and I didn't see any emotional support pony. So, I'm a little nervous. I got the exact one. And then I went and I looked through the bunch of other ones that were sort of near it. I didn't see any emotional support pony. So maybe I don't know. We'll just have to cross our fingers and trust the process. And then I'm going to start with the new judge, Sour Patch. He starts off really sour, and then he gets really sweet. Yeah. And then we're going to do a little bit of Fleischer today. He had jury selection. We're not doing that. So if I don't know how many regular I don't know how many arraignments he did. I don't know if he did any pleas. We'll grab some of those to finish out the show. Okay. Let's get started with the Sour Patch Judge.
Obliged to follow the plea agreement, and we all know that the legislature has reduced the penalties for drug charges in the state pretty substantially.
Absolutely. Thank you for your time, Your Honor.
You bet. You're welcome.
And the audio separates as we go through. You're fine. Oh, thanks, Lori.
Welcome. From the people?
Your Honor, Mr. Ortiz, he's been accepted into community corrections. We don't believe that an individual that does carry firearms and has carried the amounts of drugs that Mr. Ortiz has carried around with him is a personal use. He might be an individual that could make it through drug court and be successful, but placing an individual that's dealing drugs with other individuals that have drug issues, we don't think that that's appropriate to place them into a program where other people are trying to better themselves and get over their problems. We believe a community corrections or a Department of Corrections sentence would be more appropriate, and possibly Mr. Ortiz would be most successful in community corrections than drug court.
Okay, thank you. All right, I'll hear from the defendant.
Thank you, Judge. Mr. Ortiz's case, I think, comes down to something that was reported to the court. I think Ms. Montoya wrote to PSI that a lot's changed for him recently. And that includes what kind of sentence he's asking the court for. And that line in the PSI is that Mr. Ortiz was ready to do his time in prison, to go to the Department of Corrections, kill his number that way, go on parole, to start putting this behind. A lot's changed in Mr. Ortiz's life since then. And that progression of just trying to get out of the system to now trying to rely on it to make the changes that the court, the prosecution, law enforcement are asking him to change.
But you could be anytime you want. You let me know. I'm so ready.
Demonstrates that a drug court sentence is most appropriate for him, for Mr. Ortiz to be on probation, where he has the opportunity to receive counseling, to receive therapy, to receive treatment, to become the law-abiding citizen he is capable of being. And I want to start there and talk to you about Mr. Ortiz and the positive things that he has demonstrated. Yes, he has picked up a large number of cases in the last few years. Yes, those have involved some pretty serious offenses at the felony level. Throughout that, Mr. Ortiz was never alone. He was often working with the wrong crowd. Some of the people that he chose to associate with were close friends who were involved as co-defendants, who were definitely influencing his decisions to go out and do things that were against the law, to use drugs. In the case that Mr. Ortiz pled to, I think he was found with close to 30 grams. I believe that's about the ounce that the gentleman here said he was caught with. But we look at the TSI that Mr. Ortiz is using 3.5 grams of methamphetamine a day. That's only about a week's supply. And that doesn't indicate a bad person. That indicates somebody with a problem. And this court, the drug court program, have resources at their disposal to make sure that Mr. Ortiz can work away from that extensive use, that he can get back towards being a healthy person first and foremost, and that he can get back to being a supportive family member, a father, a son, and a member of his community.
Don't you hate when the wrong crowd that you hang out with makes you take copious amounts of drugs? Yeah.
This court is aware that Mr. Ortiz suffered a great loss, that the mother of his children passed away from a drug overdose, and that's something that has absolutely undermined his confidence, that's undermined his ability to keep
I'll send you a
pulling
link
that
right
revolving
now,
door open
Lori.
and shut. That Mr. Ortiz recognizes that personal loss is a turning point for him. And the court sees now just how emotionally that impacts. Mr. Ortiz, throughout all of this, has shown a lot of silver lining moments where he can be the respectful, coordinated citizen that this court expects. For all the days that Mr. Ortiz failed to be accountable for his court appearances, Mr. Ortiz turned himself in. Most recently, when he failed to show up for his pre-sentence investigation report, Mr. Ortiz eventually was the one. He didn't wait for law enforcement to come find him. He took care of his own affairs. He made sure his children were safe. He made sure that his family knew what was going on, and he turned himself into the jail. Throughout working for Mr. Ortiz, he's demonstrated a lot of knowledge and a lot of understanding of how the world works. He can communicate clearly. He keeps track of phone numbers and appointments. He showed a lot of accountability to me as his counsel. That makes him an absolute pleasure to work for, and it demonstrates that he is more than the activities, the behaviors that this addiction is pushing him towards. And if we want to talk about any sort of corrective action, rehabilitation for Mr. Ortiz, then sending him to the Department of Corrections is not the way to solve that issue. The halfway house program through Hilltop has similar resources to the drug court program, but my understanding is they aren't nearly as extensive or intensive for Mr. Ortiz. We could have him do inpatient treatment. That's something I imagine this court would order for him as a condition of his probation, as a condition of drug court. But it's not going to be the same follow-up. He's not going to have the same accountability to the court, the therapists, or the behaviorists who are going to make sure that any issues that put him back in antisocial circles or put him back into a drug use mindset are things that Mr. Ortiz can work himself away from. So I think ultimately there's two things going on. There's Mr. Ortiz having demonstrated his ability to be responsible and accepting responsibility by entering this plea and asking for that second piece, the help and rehabilitation that's available for him in the drug court program. He has a lot of support from his family members, from those specific counselors in the program that will drive him to succeed. He has an incredible motivation right now to be the father to his kids that maybe he didn't have a chance to experience. Mr. Ortiz is a very bright, very capable individual, and he needs structure separate from the folks that he's been running with so far. And that's something that probation with a drug court sentence can provide him. Whether those can include extra conditions of inpatient treatment is entirely up to the court and is probably appropriate. But for that reason, we're asking for this probation sentence for Mr. Ortiz to have the opportunity to demonstrate himself to the court, to the community. Thank you.
Anything your client would like to say?
I need help. Not only do I need it, but I want it. And sending me to prison ain't gonna help me. And be there for my kids.
All right, so certainly, sir, I've thought a lot about your case. You went through the drug court screening process. The drug court team did accept you, but that doesn't mean that I believe that's an appropriate sentence. I believe that you are that you use drugs at a high amount, but I also believe that you are a dealer. No question in my mind, just based upon what I've seen, the fact that you had a firearm with you, these other things. And so it's not appropriate for me to put you in drug court with other individuals who are users. And that's just the way I feel. Doesn't matter to me that the drug court team accepted you. I have the final say on that. I've also looked through your pre-sentence investigation report. You have an absolute history of just failing to comply repeatedly, not showing up for court. What did it for me in this case and just told me that you need to go to prison? You didn't show up for your pre-sentence investigation report. You like to do things your own way. And that's what you've done. And I realized that when I put you in prison, just based upon the plea agreement, that you're not going to be in there very long. But hopefully I can send a message to you that you've been given opportunities at probation, you've been given opportunities at supervision, and you just do what you want. And I'm just going to put my foot down. I realize you're not going to spend a lot of time in prison. That's just the nature of the plea agreement. The legislature has chosen to make drug crimes in the state not punishable for as long as they are. I can't put you in drug court. I don't believe you're going to be successful at all in community corrections. So, it's just an opportunity for you to reset your life, try to figure out what you want to do, start following through. You want to be a father to your kids? That's not my job to be a father to your kids. It's your job. And I'm just looking at somebody who will not comply with court orders, who is a heavy drug user and distributes drugs to support your habit. And so I'm going to take you out of society for a little while, hit the reset. I realize you'll be back fairly quickly, but the message to you is if you keep breaking the law, you're not going to get chances at probation anymore. You're not going to get chances at drug court. You're looking at going to prison if you get caught doing this again. That's the message. And I think that's the strongest message that I can send to you is you need to make these changes. You need to make those choices on your own. What's his time served? Is it 33 days?
Yeah.
I'll sentence you to 1 year in the Department of Corrections with credit for time served of 33 days. There's a mandatory period of parole. Other counts, other cases are dismissed. Looks like on your, and the other reason I'm making this sentence is because you were on probation at the time this offense occurred, which I find aggravates you. So that'll be the sentence of the court. Thank you.
Thank you, Your Honor.
Judge, we have a concurrent sentence in 18 CR 58. I just want to make sure that's.
Yeah, I'll sentence him to 6 months county jail concurrent. Okay, thank you.
All right, so that was the sour. Probation recommended drug court. He sent him to prison. Now we get to the sweet, which is still a little sour, just so you know.
Okay, Keegan Sanchez. 23 CR 233 set for sentencing today. Other cases are to be dismissed. And then it looks like in 21 CR 325, that's his probation case. Has he entered the admission in that yet?
I think that's part of the plea today, so we can do it. Wait.
I'm just so upset we can't see this lawyer better.
He has not entered the admission yet, so
Let's take his admission. Mr. Sanchez, are you currently under the influence of any alcohol, drugs, or medications?
Prescribed medications.
Okay, what prescription medications are you taking, sir? If you don't know, that's okay.
I don't know.
Okay, are those for mental health issues?
Yes.
Are you taking those medications as prescribed?
Yes.
Does taking those medications, does that help you to understand what you're doing, or does it hurt you?
They help their mood. They're for mood swings.
Okay, so taking those medications helps you be able to understand what's going on?
Yeah.
Okay.
I'm going to need a whole bottle of whatever he's taking, please.
You are on probation, sir, in case 21 CR 325. And what basically, you were on probation, you committed new offenses. Okay, so that violates your probation. Do you understand that?
Right.
You have the right to have a hearing on that, is all they'd have to prove at the hearing is that you previously pled guilty in another case. But you still have the right to a hearing. You could remain silent, you wouldn't have to say anything. They'd have to prove that. They'd have to call a witness that said you pled guilty previously and that you violated your probation. Do you understand that?
I do.
And you understand you're giving up your right to have that hearing?
I do.
Okay, and you're giving up your right to be represented by an attorney and to appeal any adverse decisions to the Court of Appeals. Any questions about that?
No.
And then to the allegation that you violated the terms and conditions of your probation in 21 CR 325 by committing a new offense, how do you admit or deny? Normally people say guilty or not guilty. I'm going to ask you to say, I admit that I violated probation, or I deny that I violated probation.
Can you be more specific? Like,
Okay,
Judge, I admit you violated probation.
do
when it was,
you admit that you violated probation, or do you deny it and want a hearing? You want to talk to your lawyer for a minute?
I don't think he's 16, no. Did they say he was 16? With his history, I don't think he's 16. More Pacific, yes.
Yeah.
so I was in jail because of probation. So the violation of the probation was protection and license. It was, no, I didn't. The rest. Okay. Okay. Few questions. So that's. I was the new charge and that violated probation. Okay, that makes sense. Yeah.
I have a Cadillac CTS, but I never drive it. It's my mom's old car. She told me I had to buy it from her, so I bought it from her. But I feel like I just feel I feel so bad in that car. I do not feel good in that car. So I make my son drive it. If he doesn't like it, he can go buy his own car. I drive my Mazda, my little crappy Mazda.
So, sir, do you admit or deny?
Admit.
I'll accept that admission as being entered knowingly, voluntarily, and intelligently. Find defendant was represented by competent and effective legal counsel. Okay, we'll sentence you on both. From the people on this?
Your Honor, Mr. Sanchez,
How are you doing, Kingsley? How are you doing? You had a scare. You had a scare. We all had a scare, but I bet for you it was. Whew. I feel like I'm 80 driving around in that car, and it doesn't. You step on the gas, and like it doesn't like go. When I just touch my gas pedal on my Mazda, boom, I'm back against the seat. Oh, I need a car that, I mean, the steering wheel heats up and the seat heats up. It doesn't have any air condition, or the heat doesn't really work in the car very well. It's old. It's an older one. My mom was getting rid of it. She said I needed to buy it, so I didn't want it to begin with. I need a Mustang. That's what I need. Although I do love my Mazda. I love my Mazda. It's so much fun to drive. I zip around. Remember NCIS? Remember how Ziva drives? That's how I drive in my Mazda. It's wonderful.
he has a number of cases that are being dismissed. They're all very similar. It appears when he's getting medication and taking accountability for his actions and being responsible with his medication, he doesn't have the same issues that he does when he's not on medication. He appears appropriate today. He's completed his PSI investigation, and we have that report. He's been accepted into community corrections. The Bridges liaison is here. I believe would like to speak to the court and his mother as well. We don't have any indication that he's been accepted into any inpatient mental health facilities, but he has been accepted to Hilltop. We believe an appropriate sentence would be something that would not be punitive, but addressing his mental health and making sure that he is able to take care of himself and is able to integrate into the community safely.
Is the victim present? Does the victim wish to address the court?
There are no victims that are present that would like to address the court, except his mother has indicated that she would like to address the court.
Okay. And just before we have her address the court, any restitution or costs of prosecution?
Don't believe there's anything outstanding. I'll just double check.
He's got quite a few cases. I'm just wondering if there's in any of them.
I don't believe there is, Your Honor.
Okay, thank you. Ma'am, if you want to come forward and speak, just make sure you state your name before you address the court.
Hello, Judge. I'm Angelique Sanchez. I'm Keegan Sanchez's mother. I wanted to address the court and ask on Keegan's behalf.
So, like, nose? Are you talking about nose, throat, chest? What are we talking about? What do they have to do? You need someone to come over and take care of you when you get out of surgery. Yes, you do. How are you going to cook your food? Take a shower, feed, check off. It's because Micro didn't stub his toe. I know why. Hi, guys.
That he not be sent to prison. He be sent to either Concord or this new facility they had just recently acquired. It's a sober living unit. It seems to be a better option for him. He's got resources. He's able to get a job and you know, establish himself in the community as a citizen that is sober and stable mind.
Okay, thank you. Mr. Crumpleman.
Thank you, Judge. I'm going to try and organize this as best as possible. Ultimately, Mr. Sanchez is requesting a probation sentence. As a condition of his probation, he's participating in the sober living community in his name. It's a home in the Durango area, and then continuing to comply with doctor's orders. He's currently working with Access, and that care would continue through La Plata County. But then I also want to outline for the court that there are options available for him at Hilltop House Community Corrections.
Kelly, when do you go in for this? How far away is it?
They have more specific requirements, and then how we might segue those two things together. Before I get to the details of how his sentence might work for Mr. Sanchez, I just want to talk about his improvement. As I'm sure the court's seen, Mr. Sanchez is a much different person than he was probably close to a year ago when I first started representing him. Mr. Sanchez was remarkably unwell at that point in time. His behavior was combative, to put it lightly, and that's clearly an issue that repeats itself through the multiple cases that are being resolved today. And Mr. Sanchez was not able to communicate well with much of anyone. It was difficult to talk with him. It was clearly difficult for him to communicate with jail staff about what his needs were. And he spent a good amount of time in the state hospital as a result of that.
Fozzie, did you hear that? Shelley said, be good. Be good.
Mr. Sanchez came back to Montezuma County in a much healthier, more open, more stable position. And that point of return, and I think that happened around March or April of this year, but I do know that he left the jail in February. And if we look at the reports at issue of Mr. Sanchez's behavior, all of those happened up until the point where he was sent to the state hospital in Pueblo. And since then, we've had no reported issues of negative in-jail behavior. The person that Mr. Sanchez was when he was off his medications, not properly stabilized, is night and day from who he is now. He's a very polite, respectful individual. He laughs. He likes to share about his cat at home. He's got a lot of good, positive interests once Mr. Sanchez is able to stabilize. And that was a large part of the consideration for the Hilltop House Screening Committee when they decided that they were going to take him on. They had their concerns, as the court and the prosecution probably do, about his reports of in-jail behavior, about his criminal history. But that seems to have been rectified by his performance and behavior since then. The condition that Hilltop House would impose is in a residential dual diagnosis treatment center. We think that if that's what the court orders, it would be more than appropriate. It seems that it would be up to the Community Corrections Board to decide which facility he goes to, when and how long that would happen. It's not clear that that's been identified just yet. But talking to Mr. Williams, the Bridges liaison, it does sound like that would take a bit of time. That's something that would probably run along the same timeline as the typical 90-day wait limit for somebody to get into Hilltop House.
Meaning he would wait about 90 days to get into the RDDT program.
That's our expectation because we don't really know. I know from working with Mr. Williams, and Mr. Williams has been heavily involved with Mr. Sanchez's cases, that it's taken a lot of time and effort to get him the opportunity he has now. Other folks that we've worked with getting into dual diagnosis centers, it just takes some time. I wouldn't be surprised if it's about that 90 days. But ultimately, Mr. Sanchez's request for the court is that he be given a probationary sentence so he can attend this in his name sober living community where he gets his medical treatment through Access in La Plata County, and he starts his sentence there. I spoke with Mr. McKinnon and then Ms. Moran in probation today about exactly how that would work. And it sounds like the court would order
You can just say you're 34. You don't have to age your boobs.
for probation. It's a pretty straightforward process. Those would be made conditions of the sentence. And as long as he's participating in the facilities program, they have a laundry list of requirements that he maintain sobriety, participate in testing, stay on top of prescription medications and doctor's orders, that he will have a place to stay. And this is something that to give a lot of credit to Mr. Williams for. Worked very hard to make sure that he had a housing voucher, and Mr. Sanchez has a place to be stable, to be consistent with, to be sober, that's in the community, and it's an indefinite period that he would have access to that sober living home. So as long as he's following their rules, he would have a place to stay and a place to get back into the community. If the court decides that the community correction sentence is more appropriate, there is a way to segue those two things together. And one of the issues that this would address by segueing a probation supervision with sober living into Hilltop House and their residential treatment program that they suggest is just the amount of time Mr. Sanchez has spent in jail so long. On this case alone, he has 364 days of credit, almost that full year. And it's been remarkable from my experience working with folks in Keegan's situation, Mr. Sanchez's situation, that he has not decompensated since his return to the jail. He's been cooperative with nursing staff, it seems, and he's been able to stay on his medications, and he has not shown any regression that gets him back to the point of concern we were at when he first went to the state hospital. But it's not clear that that is necessarily going to hold out. Mr. Sanchez is doing remarkably well. I think having contact with his mother and support from his family has been phenomenal for his health and well-being. But the jail is not the best place for him to continue receiving that kind of treatment. And it's time for Mr. Sanchez to start demonstrating to himself, to his family, and to others that he's deserving of a place in the community. So the way that probation suggests that if the court needs to order a community correction sentence, he might be sentenced to a period of probation supervision, maybe 90 to 120 days, where he would be under their supervision while he goes to this sober living facility in Durango, where he's going to have access to his medication and treatment through Access in Durango. At the conclusion, or once his bed spot opens up in the residential dual diagnosis treatment center or at Hilltop House itself, that's when he would be able to transition into the halfway house program. Again, ultimately,
Now you're saying probation's recommending that.
different from what they've said in their PSI.
So where are you getting that from?
From a conversation with Mr. McKinnon and Ms. Moran earlier today. And I think, so that is their recommendation, and this is framed by Mr. Sanchez's request, is to go to the sober living. And understanding that the court is very likely to sentence him to community corrections.
Certainly that's where I'm headed.
Yeah. And so what I'm recommending is a segue where he has probation supervision for the period that he is waiting for that bed spot in residential treatment or in Hilltop House itself. So like he's getting the best care, getting the most rehabilitation he can possibly get in the meantime.
But that's not being recommended by probation. That's what you're suggesting. I just want to make it clear.
If correct. So yeah, let's. I
just want to make it clear that that's what I understand what you're asking, but that's not what
Thank
I've
you,
read
Rebecca.
from probation's recommendation.
Right. Probation's recommendation was outside the scope of Mr. Sanchez's plea. And if we were to go this route, this is how they've suggested it could be made to work, different from their recommendation. Yeah.
Okay. Anything else?
I mean, the court has seen Mr. Sanchez's improvement throughout this time. The last few things that I need to add is that he's reestablished a relationship with his mother and grandmother. His mother says she's comfortable making sure he gets out to Durango where he can get more local cab rides or get to his appointments, get to any meetings that are necessary. They plan on getting him a phone as soon as he's released from custody. His grandmother would be paying for the time on it to make sure he's in touch with whoever's supervising him and he's in touch with his doctors. Mr. Sanchez has very limited resources in the community, but through a lot of hard work and a lot of cooperation on everyone's part, he has those opportunities finally to be in a long-term stable position that gets him out of the history the court has seen.
Anything you want to say, Mr. Sanchez?
Been pretty much explained it pretty well. I'm just ready to get out of here and continue on my journey.
Well, Mr. Sanchez, I've noticed a change in you since you've been in the jail. Yeah.
Can I add just one thing? I said there was no restitution in this case, but there was $3,000 in damage in 23 CR 195. There was an outstanding restitution request of $500 for a deductible to Christopher Dix.
23 CR 195?
Yes.
Any objection to that?
No, Judge.
Okay, that'll be ordered. So I'll order that restitution as requested. Mr. Sanchez, I've noticed a big difference in you. You know, unfortunately, you've been coming to court for well over a year now,
I hate when people assume my oceans.
dealing with these things. I think you should be commended because you have been taking your medication. Obviously, going to Pueblo really helped you. And I really hope that you just continue to take your mental health medications. That's going to be key for you in the long run. Will you do that?
Yeah.
Because I really don't think you're a bad person. I think that what unfortunately has happened with you is that the criminal justice system has become a safety net for you and for society when people have serious mental health problems. So you've gotten a lot of help. I understand what your attorney's asking for. He really wants you to get out of the jail situation. I don't think that's a good thing for you right now. I think you need to transition directly to the ComCore RDDT program. Okay, so I'm really grateful that Hilltop House has accepted you because I don't think prison is going to help you at all. I think it may turn out to be a really bad situation for you, but you do need to complete the residential dual diagnostic treatment program. And so I'm going to sentence you to 3 years in community corrections. Credit for time served with 364 days. Now, it sounds like it's a long time. Just understand that the hope is especially during the last part of your time at Hilltop, you'll start working in the community, you'll live in the community, you can go to the sober living, transitional housing. So that's the goal. Do you understand that?
Okay.
This isn't like prison. It is confining and you have to follow rules. But the idea is at the end of your time at Hilltop that you transition into the community, that you have a job, that you be living in the community, so that when you end your community correction sentence, you come out as with a meaningful life, with a job, with a place to live. That's the goal, okay? And I realize that sounds like a long time, and it is going to be a long time, but you can do this, okay?
Okay.
Are you committed to doing that?
Yeah.
Okay? So, you first need to complete a residential dual diagnostic treatment, RDDT. BAs on sign-in, mental health evaluation and treatment, grief counseling. You will have to take your medication as prescribed. Follow through with taking your medication as prescribed through to the end of your sentence at Hilltop House. Moral recognition therapy, substance abuse evaluation and treatment, and work. And you have to actively participate in all Hilltop House treatment plans. Now, I realize, I'm gonna give you credit for 364 days. I realize that means you're gonna have to stay in the jail until that RDDT program becomes available. I get it. And you're probably impatient and you wanna move on. Just keep taking your medications in the jail and just be patient, okay? Probation hopefully will start working right away with Hilltop House to get you into the RDDT program. And then you'll indicate in the notes that he may be released to the RDDT program as soon as it becomes available. Okay?
The hill people around here are Hillians. Hillians.
So hopefully you'll get in quick. All right? You have questions for your attorney or for me?
No.
Okay. And then 23 CR 195, I'll impose a 2-year COMCOR sentence to run concurrent with 23 CR 233, then 23 CR 195, 24 CR 5003, 23 CR 144, and 23 CR 257 and 23 CR 190 will be dismissed. You've got a real opportunity here for a fresh start, okay? Just,
Okay.
it's not gonna be easy, but you can do it, all right? Thank you.
Briefly, Judge, could I have the court also dismiss on the record 23M 416 and 23M 376?
Say it one more time for the clerk.
Sure. 23M 416, 23M 376.
Any objection for the people? No. So ordered.
Thank you.
This was a long time ago, people. The world was different when I did this, okay? So the last time I was outside of Pittsburgh. I was right, I can't remember what it's called. It starts with a G, but it's right outside of Pittsburgh. Um the mountains were the mountain roads were insane. So I went to this bar called New York, New York with my cousin, and it was pouring down rain, and we had to drive through the mountains to get home. The roads are like this big, the car is like this big, and you know, I was very young back then. I don't even think I was 21. I don't know if I was 21. No one carded me. Didn't matter. Um, and I had my Mustang, which is really bad in the rain, very slippery. I didn't get in an accident, but I flew through these mountain roads, and it was the greatest car ride. It was so fun. It was bad. I should not have done what I did, but I did it. And it was the greatest car ride I've ever had was in Pittsburgh. Well, right outside of Pittsburgh. Okay. Now, this is the clip. This is the um emotional support pony. I didn't see it. I'm really worried right now, but I'm going to press play and we're just going to hope together that it's really here. Did you get to fly it? Did they let you fly the plane? He let me fly on the way to no he didn't. Joking.
4099. All right, we're back on record. We have all of our attorneys and parents and parties. So Ms. Brittany Kelly coming up to our witness stand. Just remind you to remain under oath.
Was it Heinz Field or was it Three Rivers?
Ms. Thomas, whenever you're.
Ms. Kelly, I believe that I just questioned you on the police report that you had received and reviewed as part of the second investigation. Other than that report itself, were there any other pieces of information that you reviewed or individuals you spoke with to investigate the concerns in that second complaint?
No, just based off the information from the first one I had gathered, I felt like I already had a lot of information regarding the concerns.
And you stated that filing the petition, I believe, I'm trying to recall from your prior testimony, that the ongoing services had not been started yet, the family was still non-cooperative, and then there was this police report. Is that accurate?
Right.
Okay. In order to file this petition,
He builds model airplanes with toothpicks.
has to be like concern for the child's imminent safety.
Correct.
What were your concerns?
My concerns were that I had received another investigation stating that there was ongoing domestic violence still in the house.
Your Honor, at this time, I would ask to move, sorry, Your Honor, ask the court to accept the CPS investigation reports that were drafted by Ms. Kelly.
Have they been circulated to your fellow attorneys?
Yes, Your Honor.
Gentlemen?
Asking for the caseworker's report to be submitted?
Yes.
No objection.
No objection except to any hearsay references, and I'm sure the court can pull out.
Okay. Thank you, and I will disregard any hearsay, or if there isn't anything in there, I will assume that it is not for the truth of the matter asserted. I would rather to demonstrate whether or not Ms.
That's exactly what I call you. Those are the words that I call you in my head when you make me do things.
Brittany needed to do something based on what she read. Ms. Thomas, is that a copy for me?
Yes, Your Honor.
Deputy Ames, would you like to send to the bench? This will be Exhibit A. That's an app. Thank you so much. It is received. Oh, I think I have two copies. I think
No,
I will-
Your Honor, those are the two reports. There's one for the first complaint and the second.
CJ, is that good enough? Is that good enough, CJ? Come on, let me have it. CJ, can I have it, please? Does it really have to be the other two words? Isn't that good enough? Did I do it? Where's CJ? Where did she go? I'm going to say I did it, guys. I'm going to say I did it. How long did it take me? 43 minutes. Man, I got to up my game.
Is that clear to you, gentlemen? There were two.
Yes.
It is.
Ms. Unwin? Yes. Thank you. I appreciate the clarification. So we'll call them A and B.
Thank you, Your Honor. Ms. Kelly, from your personal experience with the parents, do you have any reason to believe that the child would be in harm's way?
I'm sorry, I didn't hear the last part of your question.
I asked Ms. Kelly from her personal experience with the family, if she had reason to believe that the child would be in harm's way, and let me clarify, with it in the parents' care and custody.
I'm going to object on the ground and require speculation.
Can you repeat the question? I asked Ms. Kelly, based on her personal experiences with the family, if she believes that the child would be in harm's way in their care and custody.
Ms. McFarland, do you have any objections?
Support Mr. Brooks, plus I don't think she. Yeah, I support Mr. Brooks' position.
Ms. Unwin?
I believe it calls for speculation as it's based on our experience with the family.
And maybe we need to hear what the experience is.
Ms. Kelly, were there any other interactions other than the ones you've already described that would have helped you form the conclusion to the question you're being asked?
If you're asking me about like my interactions with the family, if there was concerning behaviors, yes.
So were there other, because you talked a lot about your interactions with the with the parents so far. Are there other instances that you haven't talked about that would help support your conclusion?
I haven't personally talked about them. They were brought up earlier in other testimony though. The phone call with Mr. Hollis and the face-to-face visit I had with him, letting him, or he told me that we would have to.
You're up very early today. Thank you so much.
Kill him and get through his dogs to find his daughter. And then the phone call with him, he said that he took Melanie away and we would never be able to find her, which was concerning. I didn't know where she was. We had already had a court order, and I didn't know exactly what he meant by that.
Does it matter if you personally have risk, concern about the risk when you were in the capacity of performing your obligations as an investigator? Or is it a more objective criteria that you then have to apply to a situation?
More objective.
So can you give me a couple examples of that? What are the criteria that you have to use from a professional basis that helps you determine whether or not there's a risk of harm to the child? Are there certain things that you're asked to look for during the course of your investigation?
If there are issues in the home that that would arise to the concern of her well-being, which is a multitude of things. I guess I don't know what you're asking specifically.
That's okay. Well, Ms. Thomas is asking if you personally think there was a risk of harm. And I think that the objection is speculation, which I don't think it, I think I would have to overrule the objection on the grounds of speculation. But I'm more interested in professional reasons that you have concern rather than your personal ones.
I think that showing up as a professional and trying to speak to parents about the concerns that
She's in my shower. Do you want me to tell her right now?
are being raised in their home. I think their interaction with me says a lot. I think all the documentation that we received throughout the investigation says a lot. I don't have any personal opinions, my personal experience as a professional going to their home, I formed opinions on, but not my own personal beliefs or anything like that.
All right, thank you for clarifying. So I'm going to overrule the objection on the grounds of speculation for the reasons I've already shared during my dialogue with the worker. And she's also answered the question in the course of that. So.
Yes. And I have no further questions on this, Kelly. Thank you, Anna.
Cross-examination, Mr. McFarland.
I used to work there a long time ago.
In many of your investigations, you're familiar that many people are of the opinion that Child Protective Services, CPS, is there to take our child. You've heard that expressed, correct?
Yes.
And if that were the case in this matter, parents might be reluctant to talk to a CPS worker, correct?
Correct.
As a matter of fact, there's no order compelling them to testify, correct? There's no court order saying that they have to talk to you when you were out there trying to talk to them, correct?
Correct.
As a matter of fact, you are a mandated reporter through the state of Michigan for child abuse, correct?
Correct.
And there's an allegation here of domestic violence, correct?
Correct.
And if during the course of your discussions with either father or mother, they revealed something such as they actually did have commit child abuse, you would have to report that, correct?
Yes. Yes. I remember those days. They were pretty bad. They were pretty bad. You remember the comments I used to get? Oh my gosh. You are the first super chat ever. I remember. Oh man.
As a mandated reporter.
I think while I'm actively investigating it, I would address it as the investigator in the
Sure.
case.
Okay. You might even pass that information on to law enforcement, correct?
If there's allegations of child abuse, yes, there's policy that says law enforcement is involved.
And you would agree that they have a constitutional right against self-incrimination, which means they can remain silent, correct?
I believe so. I don't know the law that well.
Oh. So it sounds as though, correct me if I'm wrong, but the principal reason why we're here is because parents didn't wish to cooperate, at least my client didn't wish to cooperate or talk to you. Is that correct?
Correct.
Which may be the right to do, but then your right is to go ahead and file what you've done, correct?
Correct.
Okay. You've heard my client testify, and that she read text onto the record that she requested that she confer with an attorney before discussing the matter with you, correct?
Correct.
Is it true that your response was what we're discussing would not need an attorney, correct?
Correct.
You go to law school?
No.
Think you really give legal advice that you don't need to have an attorney?
I was simply stating that an attorney was not needed for me to speak with her in my capacity to do my job.
Well, even though what they might say might incriminate them, correct?
And I'm gonna object. Ms. Kelly has already stated that she's not a legal professional. Furthermore, I also think that Mr. McFarland's application, or I think he's trying to make an argument about constitutional rights, does not expand to CPS investigations. It's relating to self-incrimination in any court proceeding. I don't believe that a CPS investigation is a court proceeding.
Not correct, Your Honor. It's practicing law without a license, giving legal advice without being an attorney. But I have no further questions.
Mr. Brooks, any cross-examination?
Please. Ma'am, to your knowledge, is Melanie a special needs child?
I'm unaware if that's true or not.
You're not saying yes, you're not saying no.
Correct.
Thank you. Do you know if she's been diagnosed as failure to thrive?
No.
All right. No, she's not a failure to thrive child, or you just don't know?
I don't have the information.
To your knowledge, has she been diagnosed as having suffered any physical injuries that are suspicious?
There were allegations that she was involved in these incidents, but I don't have any, I didn't see any injuries on her the one time I saw her briefly.
Does she appear to you to be a normal, healthy child from what you've seen?
I don't think I can make that determination based on the time I spent with her.
Do you see any red flags? You go,
I'm
"Uh-oh."
always planning dinner, always.
She was running around on the porch. She wasn't verbal, but I don't know if that was because I was a stranger, or there could be a lot of different factors as to why she wasn't talking to me. But she was physically active, which was, that's a good sign in her age.
She's 2 years old, right?
Yep, I think she's both 3 in December.
I have no further questions.
Ms. Underwood? The one time you saw Melanie running around, or I'm sorry, the minor child running around, excuse me, were Mr. Hollis
Thank you so much.
and Ms. Walker together?
Thank you.
Yes.
And that was the time which a PPO was in effect?
The PPO had not been served. I believe it was served later that exact same day that I was there. I was there in the morning hours, and it was served in the afternoon, but it had been signed by the judge prior to that.
Okay. And so Ms. Walker had, to your knowledge, left the home and then returned to the home?
Yes.
Thank you, Treasurer X. Thank you.
Your job as an investigator is to try to provide parents with tools and services to avoid removing the child from the home. Is that correct?
Correct.
And you feel like, is it true that you felt like this petition needed to be filed because there had been very little cooperation from the parties?
Correct.
Was it the totality of your investigation from the police reports to the PPO, to the lack of cooperation that made you make the determination to file the petition ultimately?
Yes.
B24 Liberator. I hope you're having a good day. Miss Glow, I hope you're having a good day.
After Miss Walker indicated she wanted to speak with an attorney before contacting you back, did you ever hear from her again?
Texas burning. I hope you're having a good day.
I believe it was the same day we had the conversation, that we were texting, and we were trying to schedule a meeting. I had texted her and told her I could meet anytime before 2. I was actually off of work that day. And I was texting her throughout the day, still trying to get her to meet with me. And I told her anytime before 2 I could make happen. And I believe she texted me after 3 o'clock that day to see if I could meet with her, which I was not on my phone anymore. I was dealing with stuff in my personal life.
Okay. At one point, your investigation, Harold had indicated that Erica was smoking dope. Is that correct?
Correct.
And that was a concern, that another additional concern
Heck
you had?
yes.
Yes.
I don't have any further questions. Thank you.
Redirect? No, Your Honor. Any recross?
No, yes, based upon the GAO's line of question.
Go ahead.
If I heard you correctly, it was not because you could substantiate neglect or abuse, but because of the lack of cooperation of the parents is why this petition was filed. Is that correct?
I'm going to object, Your Honor. That mischaracterizes the question I'd asked and the testimony presented.
I don't think it does. Question was, you filed, the parents were not cooperating. I'm just trying to get some clarification on that.
What did you say the question was?
Sure. Is it true that you were not able to substantiate abuse and neglect, but it was because the parents were not cooperating with you that you filed the petition?
And I objected because it mischaracterizes the testimony. The testimony was that it was the totality of the circumstances.
Well, I'm asking the client to testify. That's not what I heard, so I'm just asking for clarification from her.
Are you using substantiate in the technical way that would be applicable in an investigation?
Let me rephrase, Your Honor.
Okay.
Was this case filed? I think you testified that this case was filed because the parents did not cooperate. Is that true?
And more allegations were received regarding the same concerns.
The allegations were received, but you weren't able to prove the substance of these allegations. Would that be true?
Due to lack of cooperation, yes.
That's exactly what I need to know. Nothing further.
Anyone else have follow-up questions?
No.
No, Your Honor. No, Judge. Thank you for your testimony. May I return your seat? Any other witnesses, Ms. Thomas?
There's Ms. Francesca Madrid on Zoom.
Yes.
I don't know if this is appropriate in a sidebar. Part of the issue that I have is that we were able to finally get the child's trauma and bonding assessment report, but the clinician who provided it to us is not available to testify today. And we just got it on Wednesday when I circulated it to the other attorneys, or might have been yesterday, what the agency did. So I was going to ask Ms. Madrid to provide testimony on parenting time, but she is not the individual who drafted the report.
So as it relates to the records received from Renee Moore and this proposed exhibit, to me, those are sort of separate issues from what we're dealing with on the question of adjudication.
Yes.
So those would only be applicable if I decide that adjudication is appropriate. So I'm open to the arguments of the other attorneys on this point, but for that report, as well as the reports completed by Ms. Renee Moore, I would need to disregard those for purposes of adjudication. So I'm not sure if we need to enter that today unless, and we have time after the adjudication.
So that's, I guess, part of my question is I don't know if that's appropriate even at this time, and then if so, I don't have the person.
Thoughts, Mr. McFarland?
I would agree with the court. It's not appropriate for the adjudication trial. If the court does take jurisdiction, review it for
Mr. Brooks?
I agree with the court. If you can't use it for adjudication, why do we waste our time dealing with it today?
Ms. Underwood?
I think, Your Honor, what you've indicated is reasonable, and we can reserve it for potential further hearings if needed.
Right, very good. So I'll ask you to do that, Ms. Thomas.
Absolutely, thank you, Your Honor. With that, I do not have any other witnesses.
Any witness testimony today, Mr. McFarland?
I have one. I've notified everybody from my witness, Laura Walker.
Ms. Laura Walker, any objections? There was a discussion about the witness list.
No objections, Your Honor.
Any objections?
Okay. All right, come on up to your witness stand.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Could you tell me your name again, too, please?
Laura Walker,
How do you spell that?
Laura.
Laura, you're my client's sister, correct?
Correct.
Biological sister?
Yep.
Oh, okay. Where do you live?
I live in Fayette, Ohio.
Okay. How often have you visited, let's say, within the last year with your sister and the child?
Before she left the home.
Correct.
Which home?
Before CPS took her.
How about before CPS involvement?
Wait, I'm sorry, I'm confused. The child or her sister? Who's
Okay,
Let me rephrase.
okay.
Have you seen the child within the last year with your sister?
Yes,
Have you seen the child with Mr. Hollis?
yes.
How frequently have your visits been? And then tell us the duration of how long they've been. How often did you go?
Probably 4 or 5 times a month.
Okay, and for how long were these visits, would you say?
It just depended on if I was going to the house to get Melanie for overnight or just for a visit or a holiday.
In and out, or a little bit longer chatting?
Yep,
Which?
yeah,
Or both?
hour.
Okay.
YouTube gives me social security numbers and credit card numbers too.
Hours.
Did you see the interaction between my client, father, and the child?
Yes.
I don't want to use the child's name because we're on the internet, okay?
Yep.
Any alarm bells that rang off in your mind that this child may have been neglected or abused?
No.
You heard the testimony presented that there may have been domestic violence, correct?
Correct.
Did you witness any of that?
No, I did not.
Did either of the parties ever tell you that there had been domestic violence?
No.
Did you ever have any concerns with the child, with your sister, or?
I don't see who's lurking. No, I don't know who's lurking. I mean, it would be hard, but when you at someone, if they're here, their name will show up. But I don't know which name to type in because I don't know who's lurking. So I did try that. I tried it in Judge Fleischer's courtroom to and then I just started typing like A, blah, 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 B, blah, 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 but it didn't work. I mean, it would take, it would be hard to find out who's lurking.
Or the father? You had concerns, what would you do? Did Protective Services reach out to talk to you about your observations?
Only the day when they came and got her.
Okay, and who did you speak to?
I don't hit the
Jill
like
and
button
another
until I know it's good.
Talk about Jill Tipton, who's sitting behind us. Anybody else here that you spoke to?
No.
What did they ask you?
They came in.
Objection,
Melanie was-
hearsay.
Well, Ms. Tipton is here, Your Honor. So. And I don't know how it's really hearsay. It's not being used for the truth of the matter. I'm just asking what was the question asked. So we're not asking to form a conclusion. We're just asking what was the questions that were asked. Let me rephrase. Did you give any answers to workers? They didn't. They asked you some questions, you said, right?
Yeah.
And you told them some statements, right?
Yeah.
What did you tell them?
That Melanie was with me and they asked me to take her over state line to drop her off in Michigan.
Okay. And why was Melanie with you?
Because the day before, Erica had called me and kind of filled me in on some stuff that was going on about CPS, and I told her to bring her to me. It was quite often that I did keep her overnight.
You jumped ahead of me.
We were very close.
You jumped ahead of me if you've ever babysat for her.
Yes.
Okay. And were you ever babysitting because there had been, you were told there's domestic violence or something like that and they needed a break?
No.
Okay. I have no further questions. We'll see if anybody else has questions.
Ms. Thomas? Thank you.
I bought these today, KS, I wanted to get rid of this thing. I wanted to get rid of this thing, so I bought these tonight. Tried to hook them up with Bluetooth, and I'm pretty good with computers. Really, I really am. I'm not just saying that, but I cannot get these to work. No sound comes out of these at all. It's very frustrating.
Ms. Walker, you stated that you spoke with Ms. Tipton?
Yes.
And isn't it true that you told her that both Harold and Erica were having into methamphetamine and probably used as recent as the day before you spoke with them?
No, I told them that I hadn't spoken to Erica for like 6 or 7 years, and there was speculation that they were doing drugs then, but I didn't think that they were now.
They're Google Pixel. I have a Google Pixel phone. Well, I have my other ones that go with my phone, and I didn't want to try them with my phone because I didn't want to. I'm old. I'll never be able to hear out of either of them again if I do that.
That's Melanie.
And isn't it true that you stated that you and Erica are not close?
Again, for 7 years, we didn't speak until after she had Melanie. But then after that, we were.
You stated that Erica called you the night before the child was found in your care and told you what was going on with CPS. What was your understanding of what was going on with CPS?
I love my Google phone. I love it.
She felt like she was being harassed and that all of a sudden they wanted to take Melanie, and I didn't really know what was going on.
Were you aware that there was a court order for
No.
CPS?
No, not until the girls came to the house.
And is it your opinion that CPS should have no valid concerns to remove the child from the parent's care and custody?
Sorry, can you repeat that?
Is it your opinion that CPS has no valid concerns for removing the child from her parent's care and custody?
Yes.
Isn't it true that you told me that mom has a long history of mental health illness?
I told you that?
Yes.
When did I speak with you? I'm sorry, I don't remember.
Were you present at the preliminary hearing on June 27th?
Yeah.
And we were in a referee hearing room. Do you recall that?
What's the question again?
Do you recall being in the referee hearing room in this courtroom with Judge Costello for that hearing?
Yes.
And isn't it true that you that mother had a long history with mental health?
Yes. Yes.
And have you witnessed any of her mental health concerns affecting her ability to parent?
No.
Thank you. I have no further questions.
Mr. Brooks, any questions?
I do not.
Ms. Underwood, any questions?
You indicated that you told Erica to bring Melanie to you in Ohio after CPS was involved.
Yes.
Were you attempting to help conceal the child or hide the child?
I didn't know what was going on. I wanted her anyway. That's why that was mostly what our conversation was about that day anyway. I actually called her and I wanted her for overnight anyway.
So you didn't believe that taking Melanie was helping conceal the child from the authorities?
No, because I really didn't know what was going on at that point.
Did you think to maybe ask what was going on before just taking the child?
Ew, gross.
I don't want you looking at
Oh,
the witness or at the parties when they're testifying.
she was crying. She was a mess. I didn't know what was going on. She was very upset, sad. She felt harassed. She kept saying, they're trying to take my baby. And honestly, at first I thought she was talking about Shirley, Harold's sister, because it's been an ongoing thing since the beginning of the year.
So after she said they're trying to take my baby, you said, bring her to me.
Yes.
Does Erica have any physical limitations that inhibit her ability to parent Melanie?
Well, she walks with a cane. But that doesn't slow her down. Of course, it slows her down, but we have a lot of disabilities in our family. We always learn to keep going. My mom raised 7 kids in a wheelchair. You know what I mean? That's just how we are. Keep going. No matter what, it doesn't matter if, I don't know. She has a hard time walking, but she still does it.
Were you aware that there was a PPO between Erica and Harold?
Yes.
Were you concerned about Erica's safety after she put out a PPO against Harold?
I just didn't know what she was going to do.
Can you clarify? Were you concerned with Erica's well-being after being made aware?
I'm sorry, financially alone, not being with mom and dad.
I'm not following your answer.
I didn't really understand what the PPO was for exactly. I just knew that she was staying with a friend, Jill Hinkley, and her husband, and trying to figure things out, and then they had it dropped.
I understand that the PPO was in place for 4 months.
Yes.
And Erica has never confided in you about any physical abuse from Harold?
No.
Did she ever call you when they would get into fights?
No.
I have no further questions.
Any redirect?
No, thank you.
No.
All right, any cross, Ms. Thomas? No, Your Honor. Thank you for your testimony. You may return your seat.
No further witnesses.
Mr. Brooks?
No.
Ms. Underwood? Did you have any witnesses?
No, Your Honor, thank you. Okay.
Closing arguments, Ms. Thomas.
Thank you, Your Honor. Been pretty honest with this court and fellow
But-
counsel about,
Where's the pony? Closing arguments. Where's the pony?
the disdain I have for the statute
Oh my God, did I get trolled? I got trolled, didn't I? I got trolled.
requires us to file petitions and we don't have cooperation from parents. Because it puts us in this evidentiary issue for trials. What can we prove? The workers are trained to look at the risk of harm for children based on the evidence that they do have available to them. When there are parents who are unable or unwilling to open their homes to talk with CPS workers to reassure them that their children are safe, to demonstrate that their children are safe, CPS workers have to do exactly what Ms. Kelly did. She had to rely on the information available to her through police reports, family contacts, and how she was treated by the parents. And this court must find by preponderance of the evidence that at least one of the allegations in the petition are true to the extent that there's been a violation of the juvenile code. Throughout the trial, the parents' testimony has attempted to diminish the concerns about their relationship dynamics and what the child has been exposed to in her short period of life. The dynamic of protecting one another is exactly the issue that Ms. Kelly ran into during her investigation as well. Nothing was clear in her investigation. There are potential things that may or may not have been true. We're not sure if Ms. Erica Walker was telling the truth during her testimony in court, or whether she was making false police reports, or if she was not telling the truth to community members like Catherine Cobb Domestic Violence Shelter to wrongfully utilize those resources and waste them on a family who does not actually need them. We don't know if she filed a false PPO, so essentially lying to the court. We have no idea what is true. Her testimony is that all that information only exists because she was angry with him for saying he was going to take their daughter. And Mr. Howell's testimony was he was angry with her at times for taking their daughter. Both of them denied any anger management issues, yet we heard a phone conversation in which Mr. Hollis was pretty aggressive. We have the CPS reports and that have been admitted into record in which Mr. Hollis is telling law enforcement and CPS to get the fuck off of his property and lunging at them and being aggressive in that way. We have a lot of indications that that's not true. And the blame that the blame that we are hearing is being shifted, I guess, or the responsibility of CPS becoming involved is being shifted to Mr. Hollis's sister. That Mr. Hollis's brother and sister simply just didn't like Miss Walker, or that they're trying to take their child. And even if, like, we don't have proof of that, though, we're just hearing what they say. Even if that were true, I guess, maybe those concerns from the family members were valid. Maybe there should be valid concerns for the safety of this child, especially from an individual who lives there with them, or an individual who also is helping build a fence around their home. Like that seems very interesting to me. So we have this child who, at worst, if we accept all of the information that Ms. Kelly had as true, at worst, this child has witnessed and experienced domestic violence while in the arms of the same individuals who are charged with protecting her. And at best, if none of that information is true, and we believe the testimony of the parents and Ms. Laura Walker, this child is in an environment with parents who would argue or get angry with one another, make up lies about one another, and use her as a pawn piece, threatening to take her away or actually keeping her away from the other parent. All of those things, whichever way you look at it, clearly pose a risk to the child's physical health, emotional health, or mental well-being. And for those reasons, I believe that this court can find by the preponderance of the evidence that the juvenile code has been violated under MCL 712A.2 A and B. Thank you.
Mr. McDonald?
I come up here for the court this evening. Your Honor, our Constitution really has no legs unless it protects activity that people may not appreciate, may not like, might be disgusting to some. My client has an absolute right not to speak to protective services. She has an absolute right not to incriminate herself. So yes, we concur that Child Protective Services has a right then to go ahead and file with the court here. We may not like parents arguing. I can see where parents thought that their child was going to be taken from them, how they might use language which might be offensive. It's still protected speech, Your Honor, under the First Amendment. When we've asked the worker here what she was able to determine for abuse, they really haven't been able to determine abuse. There's a PPO asking my client under oath about that. Obviously, she didn't know what narcissistic meant. She didn't know what gaslighting meant. She was awoken in the middle of the night, asked to fill this out by Catherine Cobb. Appears to be part of her staying there. That's what has to be done. But she indicates that she was ticked off at the father of her child. Thought that he was going to take the child, so she did that. Her testimony from the father of the child, Mr. Hollis. He thought she was going to take the child, so he was making remarks about her. Still, even if these things happened, we have no testimony that this child was in harm's way, that the child was neglected, that the child didn't have food, the child didn't have shelter, the child didn't have appropriate care. We don't have proof of abuse, Your Honor. So what if parents were arguing? Parents argue all the time. I don't know of any couple that have a child in common that don't argue. Does that mean that we need to have involvement of CPS? No. If a child was present while they were arguing, we still don't have evidence that there was harm to the child. We don't have any evidence that the child knows what the conversation is, and I doubt that a 2-year-old knows the vocabulary, knows what's going on. Or we don't have even testimony that the child was present in the room or could hear. It's just absent on that, Your Honor. We are looking at a preponderance standard. I don't see by preponderance that we can demonstrate abuse or neglect. We can demonstrate that clients exercise their constitutional right. Under oath, here in court today, she testified that what she said, what was mentioned in the PPO, which she did not write, was not true. She was doing that to get back at Mr. Hollis, what she thought was going on. We also heard my client's sister, who appears to be truthful today, who doesn't know of any issues of abuse and neglect, who says that after this child was born, her sister turned her life around. We don't have any evidence of drug use. So, don't have any true evidence of mental health neglect on my client's part after this child was born. I just don't think we have enough here. I'm sure this case, these parents are going to be monitored for any future calls, any future concerns, but I just don't believe, based upon the proof presented, that we can say by preponderance, abuse and neglect, that this petition can be substantiated. Thank you.
Mr. Brooks?
About 10 years ago, there was a hit comedy show on TV. It's called Seinfeld. It lasted 7-8 years. Lasted a long time. That show, they were proud to say, was premised on nothing. Somehow they made that into something. I submit this trial is premised on nothing. No evidence of the child being injured or harmed in any way. There's no evidence of malnourishment. There is no evidence of failure to thrive. There's no evidence of domestic violence other than Mr. McFarland's client saying that she admits she lied about it. There doesn't appear to be any injuries apparent on the mother. All you got is somebody somewhere, and I don't know who they were, accusing these people of having a domestic violence which is threatening the child. But they weren't in here, were they? I never saw them. I never heard them. I see that the prosecutor or the attorney for the department has practically turned herself inside out trying to get hearsay type evidence in for the last 2 days. Why would she go to that trouble? Because there's nothing else. It's air. Sometimes, yes, they would have the right for my client and the mother of his child refusing to cooperate, but you still got to prove it. That raises an alarm for review by the court. But you've still got to review the evidence, and there is none. I ask that you dismiss this case.
Ms. Underwood.
Oh, Fozzie.
Your Honor, this
so
petition is
nice.
not indicating that the child was physically abused. The petition is indicating that the child was put at a substantial risk of harm because the parties were involved in a long-standing domestic violence relationship, which was evidenced, again, Miss Walker testified that she did call the police saying that Harold had abused her while Melanie was in her arms in 2022. There was another police report that Erica herself did testify to, stating that she told police that she had been physically assaulted, punched in the jaw by Mr. Hollis. She then signed a PPO with allegations that she admitted to telling the Catherine Cobb workers that are incredibly similar to what she testified to regarding what was stated in the police reports. Your Honor, people don't go through the trouble of contacting police multiple times, seeking refuge from domestic violence shelters, and trying to escape domestic violence, only to state that it was all a lie. That in and of itself is concerning to me as a GAL. And again, CPS needed to rely upon the PPO and the police reports and the evidence that was presented or provided in order to file this petition. And again, Erica's testimony stating she was lying. I mean, she's not a credible witness if she was willing to go through all of these lengths. She also testified that Harold was a changed man as soon as Melanie was born. Mr. Hollis indicated that Erica was smoking dope, so there are concerns there with substance use, along with the fact that Erica admitted herself to not being willing to submit to a drug screen as requested by CPS. Again, CPS was there initially to attempt to help this family and provide them services so that they could provide a minor child with more stability and less harm. However, the lack of cooperation, along with the other allegations in two different investigations, left Ms. Kelly and the department no choice but to proceed with this petition.
Ms. Walker's sister has indicated that she was aware that CPS was involved. I told her sister to bring her across the state line to her home when Erica indicated that they were trying to take her. That is concerning as well. Ms. Walker deliberately kept the minor child from CPS when they attempted to just do a well check on her and make sure she was safe. While Mr. Hollis was somewhat cooperative, he continued to willfully violate the PPO that was in place up until August of 2024. It's my belief that Ms. Walker is probably not comfortable telling the truth in front of the court when the perpetrator of her violence is sitting right in front of her during her testimony. I am very concerned for the well-being of this child, considering all of the facts and circumstances surrounding this petition. I think it's in the best interest of the child to be in the care of relative placement while this family receives some services to help become better parents for their child. So I believe that preponderance of the evidence standard, more likely than not, I believe that the department and the witnesses presented more than enough evidence to hit that preponderance of the evidence standard, both for Harold and for Ms. Walker. Thank you.
Well, the court finds all interested parties were given notice for purposes of today's hearing requesting adjudication. We did, of course, continue this from Tuesday in order to make sure that all of our witnesses had the opportunity to testify and all of our attorneys had the opportunity to ask any questions they may want to ask.
Victoria and Jen's here. Which chat am I in? I need to delete comments. Oh wait, no, this is mine.
Underwood is correct when she references that the standard here is a preponderance of the evidence as to whether or not the aspects of the statute have been violated. And in this case, it is the sections 1 and 2 that Ms. Thomas referred to. That is whether or not the home or environment created by the parents is unsafe to the child, presents a substantial risk of harm to her mental well-being as a result of neglect or refusal to provide proper and necessary support, education, medical, surgical, or other care necessary for the child's health or morals. In section 2, whether or not the child's home or environment with the respondent parents, by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent, is an unfit place for the juvenile to live in. The parents failed to cooperate, but also didn't fail to cooperate in many ways. They did have some interactions with the department that demonstrated some of the concerns that were brought to light during the trial today. And some of the concerns that I think probably caused, obviously, there to be a complaint made to the department and a request for investigation. There were concerns that arose to the level that required police response. We heard about 2 different incidences, I believe in April, and then there was another one during the course of the investigation in June. So I've heard the story from what Ms. Kelly was able to put together, and I, of course, have heard the testimony of both parents. I've been able to listen to that voicemail that was produced by Ms. Thomas. And what I've been able to put together as far as the findings is this. Ms. Erica Walker seems to be, who is the primary caretaker of this child, calling in police or being at least part of police intervention for what she's claiming and what they are claiming as domestic violence incidents. She then leaves the house and either seeks shelter at Catherine Cobb or couch surfs, and Mr. Harold Hollis may or may not know where she is. I believe him when he says that when the cops came to his house that he had not seen her in days. And I think she substantiated that as well, at least in part during her testimony. So we have here either a very unstable parent who at any point in time is just willing to simply up and leave the house and couch surf and lie to Catherine Cobb about domestic violence and lie to police officers about domestic violence and lie about the fact that she may have been being chased by Mr. Hollis, or we have a very unstable woman who is
what?
willing to say these things, and take a very young child with her as she does go through these particular episodes where she's very clearly in fear for herself. Whether that's realistic or not, that's really concerning as far as a primary caretaker role for this child. So I think there's clearly a preponderance of the evidence here that Ms. Erica Walker has created an environment for her child that's unsafe. She's the only demonstration of housing stability that we've seen here is when she stays with Mr. Hollis. And when she's gone, he doesn't know where she is. And it was unclear from her testimony where she is or where she has been. She's couch surfing or ending up in shelters. At one point, she ran out of gas on the side of the road and was in a ditch, apparently. There's no indication that I don't know where she is or where this child is at and whether or not she's safe. So the other piece to that too is that this child seems to have qualified for early on services and was not being submitted for those by either parent. So I do see there's a preponderance of the evidence here as it relates to Ms. Walker that in her care, there is a neglect of the medical care necessary for the child, and that there's a substantial risk to her mental well-being to be taken around with Ms. Erica Walker during these episodes, and that is in a home or environment with her because of that same neglect and potentially criminality, including lying to the police, lying on a PPO application, lying to representatives of Catherine Cobb. That creates an unfit place for this juvenile to live in. And whether it's because her allegations of domestic violence are true, or whether because Mr. Hollis simply fails to take action when Ms. Walker goes AWOL with his child, there is certainly a preponderance of the evidence here that if entrusted to provide an environment where this child, let's just say, receives the medical care she needs through early on services, regular doctor's checks, and to ensure that she's safe from a person who is either around a domestic violence situation or is in the primary care of a woman who is very unstable, whether that's from substance abuse or untreated mental health issues, and allows that to be part of his home or environment where this child is supposed to be living safely. So I do think there's a preponderance of the evidence as it relates to both of these parents, and I am taking jurisdiction. We're going to set a disposition date, and it's going to be immediate order of the court. A referral will be made for a psychological evaluation right away for both parents, so that at the disposition, I can understand more clearly what the issues are that are plaguing this family. Clearly, we have potentially issues of domestic violence, or at least the dynamics of domestic violence in the home. And I would harken back to Ms. Underwood's observation, which I also made, that Erica said he's a changed man since we got married. Well, what does that mean we were before? And people simply don't change overnight. We have all of the police reports and those allegations. So at a minimum, we have these dynamics in place. I want to know why and what we can do to help this family move forward past those to create an environment where the two of them are safe, able to avoid arguments, and that the child has a good, safe environment where she's going to have needs met. So let's schedule a disposition. Between now and then, the two of you will be asked to work with a case, to work on a case services plan to identify the things that you want to work on in order to improve the environment for your child. And we'll come back together and look at that within 28 days. It puts us in the first week of October. Looks like what I have available would be Friday, October 4th at 1:30.
Yeah, I'm not available.
Are you gonna be out that weekend, or can you tell me which days?
Friday, I just can't.
Okay, thank you. Well, that's all right, I appreciate you letting me know that. I'm gonna put a note here so I don't try to schedule you again. May have to move it up a little bit, which I know puts a little pressure on our caseworker to get that done. But I'm not sure there's any other way to do it within 28 days.
May I say,
Okay, so they're gonna just talk about dates and then reset. So we're good. Now we're going to go to Fleischer, and he has a trial. So yesterday they picked the jury for the trial, and nothing can make me play that here because I'm not going to. But it's on his stream, so go for it. Go watch jury selection. It's super exciting. I'm just gonna see if I can find any arraignments or anything. Wait, what is this? This is only 12 minutes long. My bad. It's my first day.
Did we go ahead?
Stand over here, right in the middle.
Okay, there you go.
Morning, Dr. Byrne.
How are you, sir?
Thank you for coming.
Thank you for letting me come.
Yes, sir. Hey, guys, keep it down, will you, please? Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Excuse me, Your Honor. Hold all conversations or take them to one of the witness rooms, please.
Officers were dispatched to a crash in Harris County, Texas. The wheel witness stated that he was towing a car when the defendant crossed into his lane and hit the car that was being towed. The defendant told officers that he drank 6 Bombay Sapphires and did not know he struck another vehicle. SFSTs were conducted, 6 out of 6 HGN, 8 out of 8 walk and turn. The officer did not ask the defendant to do the one-leg stand due to balance problems and age. DIC was read and breath consented, 0.139, 0.135.
Prior to DBIs?
Yes, sir.
Okay. Mr. Byrne, I'm going to find that there's probable cause to go forward with the case. The only thing I'm ordering you to do is not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming any kind of alcohol or illegal drugs, I'll put you in jail. You will not get any more PR bonds. You've got a great lawyer helping you out. I will waive your appearance so you don't have to waste your time coming to court here, but you must stay in touch with Mr. Alford and he'll tell you when you have to come back to court. So you're welcome to go back to Florida if that's where you're going to go, but understand if they call you for a drug test, you'll have to test at Quest Diagnostics, get the test to Mr. Alford, and that'll satisfy us, okay? So just be careful. Don't pick up any new DWIs. Just, you know.
Probably not.
Well, you have any questions for the judge or anything I need to ask?
I don't know what to ask.
Good,
Thank
that's a
you.
good answer.
The only other thing I'm going to suggest to you is that it's very possible because this DWI, you might lose your license because of the administrative license case that you have versus DPS. So just stay in contact with Mr. Alford. If it does become suspended, you can't drive. In the event you do, you can always get an occupational, but just be wary of that. Okay.
Thank you, Judge. I've already requested a hearing.
Great. We'll just have you sign a reset. We'll have you meet with the pretrial and then you guys are good to go. Okay.
Thank you, Judge.
Thank you, sir.
Happy travels.
Thank you.
Sanchez, Ramon.
Yes, sir.
Counsel.
Ramon Sanchez, come up.
Judge Sanchez, he was released from custody and needs bond conditions.
Okay, that's a good idea. That's a good idea. Guys, you know how we don't like adulting at all. All we have to do is just use the bond conditions. That's what we'll do. That's how we'll live our no, 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 no. Don't do that. Never mind.
Ricardo. So this is what we're going to do. We're going to wait for your lawyer to show up. Take a seat for me at the jury box. Don't go anywhere, sir.
All right, Judge, Rial, page 22, Brianna.
Good morning, ma'am.
Sir.
Ma'am, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 15th, 2024, officers conducted a traffic stop on the.
We've already given.
Gave her one already?
I gave her one, Victoria just gave her another one.
Does not work? Well, if it's not working, it's not working.
When my brain needs a break, I play Skyrim, and it's been calling me, but I can't even open it because if I even open Skyrim just for a second, there will be no videos.
All right, sorry, Mark.
Oh, okay. On October 15th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it failed to signal a lane change and swerve left and right within its lane before striking the curb. Officers observed the defendant to be the sole occupant of the motor vehicle and detected an odor of alcohol and bloodshot, watery eyes on the person. Defendant admitted to drinking. SFSTs were conducted 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DICs were read and defendant consented to breath test 0.163, 0.161.
Where was this?
It was east on Clear Lake City Boulevard.
Okay, all right. Because I'll explain to you later. All right, ma'am, I'm gonna find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol and kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
I have regular insurance.
You have car insurance in
Yes,
your name?
sir.
Okay. We're going to reset your case to give you time to hire a lawyer. Don't sit and wait because you're only hurting yourself. You need to talk to a lawyer immediately because there's a lot of timing requirements. I'll have you sign a resale with Victoria. We'll have you meet with pre-trial for your bond conditions, and after that, you're free to go.
Yes, sir.
Okay?
Thank you.
Please.
All right, Judge, next is page 1, arms, come on up.
Oh, any priority to be eyes on that other one?
No, Judge, no criminal.
Good morning, Mr. Arms. Sir, you're charged with assault of
Are you shouting at us? You know that could hurt us. That's assault.
a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Defendant and the defendant are married, and on October 1st, 2024, officers were dispatched to a family assault in Harris County, Texas. Complaining witness and the defendant got into a verbal argument. The defendant stated he was going to take the car and leave. The defendant then pushed complaining witness against the car with both of his hands in her chest, neck area, causing pain. Complaining witness stated the defendant held her against the car for a few seconds and then let go and proceeded to leave. Officers observed redness on complaining witness' upper chest and lower neck and on her back.
Do you know?
I know that it's his wife.
She's here. If she wants to have, she's here. Contact with him or no? She's here. Don't say anything, Mr. Arms, please.
It looks like this is a DVD case. It looks like we haven't gotten the chance to reach out to her yet. I believe that the defendant is saying she's here in the courtroom right now.
Is there a Haley Arms here? Okay. Are you Haley Arms? Okay, just take a seat for me momentarily, ma'am. You want to reach out and see what she wishes? Mr. Arms, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any threatening or harassing contact with this person. If you violate these conditions, I'm going to put you in jail. You will not get any more PR bonds. I'm also ordering you not to be in possession of weapons as well. Do you understand?
Yes, sir, I do understand.
There is a protective order that has been in place. I would get to know it because if you violate this protective order, the state can and will file additional charges against you. And then things will really go sideways quick. Are you on probation or parole at this time?
No, sir.
Okay. So for now, what do you do for a living, sir?
I work for my wife, home health care.
Sorry?
Work for my wife, part-time, home health care.
For your wife.
She owns a home health care service.
Okay. And what do you do make a month?
Work like 6 days a month, about $285 a month.
Why not a regular job? 9 to 5 that every day?
Because of my criminal history, sir, I have a hard time finding a job.
And the more you pick up, the worse it gets. How old are you, sir?
I'm 39, gonna be 40, sir.
39.
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol and any kind of illegal drugs, likewise, I will put you in jail. I'll have you fill out an application. I need to know everything about you, how much money you make, how much money you have in the bank, and then I'll take a look to see whether you qualify for an appointed lawyer. But understand that you're under strict supervision now. I don't want any more issues. Otherwise, there's only one place. Do you understand?
Yes, sir.
Okay. Do you mind giving him an application? It's right here. This one, yeah. If you just give him one, we're going to give you an application. I'm going to have you sign a reset with Victoria, and then we'll have you take a signature.
I played Baldur's Gate a little bit. I was so excited to get Hogwarts. Oh God, what is it called? It just came out not too long ago. What, like, I don't know, I don't know how long ago it came out. I played that for like 2 hours. I don't know. I tried the new Diablo. It just wasn't the same. I'm about to go back and play my old games. Dungeon Siege.
Box for now, sir. Do not leave, okay? All right.
That's it.
So don't worry about filing conditions because I'm gonna make sure he's monitored. The criminal history kind of worries me.
Bye, Maiko. My kids play Honkai Star Rail and Genshin Impact a lot, but it's like a money trap. And I keep telling them there's so many other games that you could play that you don't have to spend all this money on. But no, they work just so that they can spend money on Honkai Star Rail.
Right here. Council for a reset?
Hey, Chris is back.
Hey, Stephen.
Everybody.
Stephen.
Stephen, lock him up. Lock him up.
Oh, it's right here.
Yeah, already told it.
I was gonna add more. It's not a big deal. Don't worry about it.
Are you adding the next? Jury? You adding another jury?
No, don't worry about it. It's not a big deal.
You just throw something, you eat it.
What is going on?
Hey, Frederick, what's up, man?
I like the decoration.
Thanks. Try to be festive, you know?
This is where I came in, right? Yes.
Yeah,
I
it's
was
gonna be
only a
fun.
few minutes late.
Your turn.
YMAT or some, one of those facilities. And
I'm not gonna send you to WIMAC just for a simple.
yeah, back in the day it was.
Not just for, he meant,
Trust, I researched it. No, I researched it, Judge. I'm telling you, it was in one of those courts. It was a long time ago. And I looked at everything and I thought the same thing. I mean, he can tell you.
perhaps it was an ag rob pled down to a theft.
No,
Who knows?
it was not.
That would even been very good.
There was an employee theft? I was working at Office Depot, yes, sir.
Regardless, I ordered you not to consume alcohol. Just because you had a theft when you're 18 doesn't allow you to consume alcohol now when you have a DWI.
Yes, sir, I understand.
Now I'm going to put an ankle monitor on you so I know that you're not consuming. And the next time you do, you will go to jail. There's no excuse. I don't care what I don't what you care. I don't care what you're telling me. I don't care if it's NyQuil, mouthwash, a tequila lollipop, hair dye. I've heard it all and I don't care.
Yes, sir, I understand.
Next time you will stay with me. Do you understand?
Yes, Your Honor.
This thing is extremely finicky and it detects alcohol through your perspiration. So be careful where you go, what you do, who you're with, because I won't entertain any more excuses. Do
Yes,
you
Your Honor.
understand?
Yes, Your Honor.
Take a seat, please, sir.
Yes, sir.
All right. No tolerance, Mike.
I was just saying that's why we have to apply police call. I mean, what, that's what you need to do.
All right, bud.
It's okay. It's okay. I'm not gonna bash Fallout, but they made Fallout, they made Skyrim. You're gonna play Fallout? I've never played that. I used to play a ton of MMORPGs. Aeon, remember Aeon? Guild Wars, Last Chaos. Good to know. Thank you. Thank you for saying that to me.
For which one? Oh, no alcohol, no drugs, random urinalysis. It's a DWI. Hey, Mr. Haddad, can I give you a cause number?
Yes.
253.
253.
5018.
505.
253 5018. This case is to me, it's pretty egregious. And I'm asking you to remind me when we do get this individual in here so that I can take appropriate action. Because I just want you to remind me so that I don't forget. And they try to like either waive PC and they get out of here because it's.
Right. This is for, to be clear, James Pinker. Right?
Yeah.
Okay.
I'm signing the warrant now, so that way when we do get him.
You should.
You'll see. Okay. He's been negative. How many times have we tested Mr. Osborne, please? It's nearly 400 days old and he's continuing to smoke weed. I mean,
This is the first time he's actually been tested, to my knowledge.
I don't think that's right. I think that we've tested him before.
I understand he tested positive, Judge. My only concern is he is trying to degree and he's, I mean, obviously through his own doing, he's missed a lot of days of school, but I'm concerned that he's not.
Since December 21st of 23, He has had a dismissal offer where he's had to do 12 hours of community service, one class, and he gets his case dismissed. Now, a year later, we are still here and he's testing positive for marijuana.
Only number I had for him was his mother's number, which is why he initially, and it got disconnected. I could not figure out how to contact him, which is why I had the PTI offer, but I couldn't reach him to give him the
It's not your fault, Mr. Schofield, and I'm not going to let you fall on the sword for him. But you're still smoking.
Only one judge.
Just the one today?
Yes.
We've never tested him before?
And we have a record now.
Apparently it's.
Where are we going?
He signed the PTI yesterday, so he's just got to get his community service and his anger management done.
What kind of anger management class are we talking?
Our anger management class, and he has 12 hours community service.
You have 3 weeks to get everything done. If you don't have everything done in 3 weeks, you will get an immediate trial setting. This offer goes away. Do you understand, Mr. Osborne?
Yes, sir.
And the next time you test positive, I'm going to light you up. No more weed. How old are you?
18.
No more weed. Do you understand?
Sir.
You will get tested again. And if I find that you're continuing to smoke weed, into jail you will go. You have 3 weeks to get this thing done. That's it.
Thank you, Your Honor.
Hey. Hey.
That's 3-1, Judge.
What's the last name?
Tomas Gonzalez.
What page is it on? Is it on docket today?
Page 14.
Yes.
Marcelino, okay. Mr. Marcelino Gonzalez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that by pleading guilty to this offense, it will go on your record. It's going to be there for the rest of your natural born life. If you ever get pulled over in a car and you have an alcohol on your breath and the officer sees that you have a prior DWI, what do you think they're going to do to you?
Tase you.
Right.
Yes.
What we're doing today, you will now be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? And if you are not in this country with permission, you go to jail for that time. I can all but guarantee that you will get an immigration detainer. So if you have people that depend on you for whatever purpose, you going to jail for that kind of time completely wastes them. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. It will go on your record. It will be there until the day you die. Do you understand?
Yes.
Do you still want to do this?
Yes.
How do you plead to the offense of driving while intoxicated? I will find you guilty, sentence you to the 3 days in jail, give you credit for the one. I'm going to suspend your license for 90 days. Do not drive until you get a license. Otherwise, you will be right back over here. Are you appointed on the case? Okay. You let me see some. Good luck to you, Mr. Marcelino. 3,000. Oh, it's 3,500. You have,
You can't put 35, Judge. It's either 3,000, 4,000, or 6,000.
45, 45.
All right, guys, I'm going to find him. I'm going to end on him because he's in here twice, and I can't leave without finding him. I think the first time we see him is after jury selection, right? Michael left. Linus, was it after jury selection? That's not him, is it? Is that him? I don't think that's him. This is him. Where is he? Where is he? Where? All right, that's him. No, it's not. Help me. Is that him? Linus, that's him, right? I think so. Okay, so now we're gonna look for him. We're gonna look for him before now. That was definitely him because there's Mom. Come on, buddy, where are you? Boring, 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 boring. We didn't already see him. Yeah, but where's him at the beginning? Did we already see him? No. I mean, I wasn't really paying attention, but no, 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 we didn't. He's here at the beginning, and then he comes back at the end with a tiny discussion about him in the middle. Boring, 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 boring. I mean, super exciting. All right, so this is the trial. So before, that's not him. He's dressed in a suit jacket. Is that him right there? Hold on. Does that look like him? Hold on, hold on, hold on.
Okay, please. All right. Okay, guys, we're going to bring a jury in.
All right, that wasn't him. All right, so I'm going to go past the boring part. Super exciting part. My bad. We're looking for a guy in a suit jacket. Linus, is it possible that they just spoke about him earlier and he didn't actually come up earlier, they just spoke about him? All right. Hold on. Guys, you got to hear this. I just don't know when it was. Was it him? Hold on.
They didn't take his.
We sent them a court order. Hey, Vic.
Yeah,
I don't know
think
what
this is
happened
him.
over
I
there,
think
but-
this
Happened
is
with
him.
Terrell.
Hold on, hold on, hold on. I think so. So I'm gonna go back to here.
Thank you.
Thanks, Connor. Gosh. Hey,
How you doing today?
what's up?
Tyrell, Ian Tyrell,
Is he even here?
sent him for a drug test.
What happened?
So I'm having a problem.
He took off?
No, he said, his dad, I've been in touch with his father. He's saying that, he's not coming back upstairs. They didn't take, they're telling me that they didn't take his.
We sent him a court order. Hey, Vic,
I don't know what happened over there, but.
what happened with Terrell?
Check.
Terrell,
Uh-huh.
I sent them to get tested, on email and pre-trial this week back.
He's saying they're not taking his.
We sent a court order so that he could do it. So he should be, he went there originally and they didn't take him because they didn't have a court order, but we sent an email about 3 hours ago to pre-trial to get the
Now his
order
father
done.
is saying he's not feeling good. He's threatening suicide, you know, all this kind of stuff, and he doesn't want to come back upstairs. That's what they're texting.
All I wanted is
I have
a
to
drug
wait all this
test.
time.
You can always zoom in if you need to, but
Can you roll him till tomorrow to figure out what's going on?
no,
if it's
I
a
want him
safety
to
or-
go take a drug test right now. I want to know what's in his system. You know, if he doesn't take the drug test, I'm gonna revoke his bond. I've had way too many issues with Mr. Terrell.
And this is the
I
guy who
don't-
was
I
in
don't-
rehab. Remember I showed you the proof that he was in rehab?
Yeah,
Now he's an IOP. Now, I understand he
I
needs,
sent him for a drug test this morning for a reason.
we both, Judge, we both know that he needs help. That's not in question. But it's just how to manage him and how to control the situation. That's what I'm trying to figure out.
Doesn't do anything. He just keeps using. That's the problem. And we try to
What do
get,
you recommend?
first thing first, we would have to get a TRAS done to see what the recommendation would be. But I need to know what's in his system. And that's why we sent him for the drug test now.
I emailed them. I know they're in the building, so.
Where is our pre-trial person?
Well, because of the trial, she, Jessica,
Give me a second, Yasha.
I have like 100 text messages from the father.
So good. Touched my soul.
here to go, Judge.
You made it. We need to find out what's going on with Terrell.
Oh, that's the reason I came, Judge. So whenever he was submitting his drug test, the tech saw it was fake genitalia, and he told him to take it off. He didn't, and then he left.
There you go. He needs to come here. He needs to come right back to court.
Well, yes, but after, he knew that, but after that.
So did he
now
take
he's
off?
gonna come back.
You see what you hear?
What does that mean?
What does that mean? That guy. Oh man.
He had a fake penis that shoots out urine and keeps it hot so that it looks like it's he had fake genitalia.
Never heard of that one before, Judge, but
No, we hear it all here. They have all kinds of stuff here. So that's what's going on. So
what do you
he has-
recommend, Judge? I'm here
he has to
not to
come-
delay anything or being an
Has-
obstacle or anything like that, but I'm just trying to help the situation and his situation, you know?
Number one, he has to come back here. Number two, you need to let him know that it's very possible they file new charges on him for trying to falsify drug tests because it's a Class B misdemeanor, just like everything else he has, And
What should we do with him right now?
he has to come back to court.
Okay, if not, then
Booking his bond.
you can't roll until tomorrow, so I'll be here.
No,
Okay.
he's fooling us. Yasha?
I'm trying to figure out what's going on. I mean, all this is short notice, Judge, you know?
He has to come here. Bottom line.
I'll let him know.
Let him know. I have another at least half hour here. If he's not here by 12:45, I'm revoking his bond. Let him know.
And if he does, can you let me know so I can zoom in, Judge?
Yeah, zoom in. I think I have your cell phone. If he shows up, I'll text you. Let me make sure I have your phone. The 630,
Yes.
I'll text you. he shows up, let him know he's gotta be here.
All right, thank you, Judge.
Hey, Judge, the correct term is resonator. Resonator.
Yasha, look it up. You're right. You're right.
Normally, I would research for you and I would bring pictures over. I can't really do that today, guys. I'd like being monetized. So we're sitting here this whole time, right? Good question, Chaos. We're sitting here this whole time wondering, is this guy gonna show? Is this guy gonna show? Is this guy gonna show? Then we get to the very, very end of the docket, 4 hours in. Melissa. But you have Vans.
Stephen. Almost. Dasha? Dasha?
Judge, can you hear me?
Okay, I got you. Okay, Mom, come on up. Come up, Mr. Terrell. You are.
His parents, William Tyrell, his dad, oh, sorry, and this is his mom, Rosanna Tyrell.
Are you familiar with what he did today?
We're familiar with what they said. We don't agree that that's right. We also agree that he's being held accountable for things that aren't really applicable in this case. You know, and
I'm asking him not to use drugs or alcohol.
I know.
That's all I'm asking him to do. And he's constantly testing positive, and now he's taking a Whizzinator into the room.
Well, it's wrong. And we don't want.
He can be charged criminally for that. That's an offense in and of itself. Falsifying a drug test, it's a Class B misdemeanor. You're facing another 6 months in jail and or a $2,000 fine.
What about, I mean, our concern and his concern is simple. This girl.
I'm not, no, we're not talking about the case. We're talking,
What is the case?
no, we're talking about the ability to remain clean and sober, first and foremost. We're not even talking about the case at this point. We're only talking about remaining clean and sober. He's repeatedly been unable to do that. And now he's trying to fool us.
Well, he has an issue that we know.
Okay. I think what needs to happen is I think the first thing you need to do is you need to talk to your lawyer before you make any statements.
Yes, sir.
The only thing I'm going to say is that I'm extremely upset, disappointed, and taking him into custody. You know, you've repeatedly failed to appear for court. You've repeatedly tested positive for a lot of substances, and now you're trying to fool us yet again. It's unacceptable, and there has to be accountability, and you need to accept that you can't continue to do what you're doing. Mr. Terrell, you're digging yourself into a hole that you cannot crawl out of. This monkey on your back will be there for the rest of your life, and if you don't get out of it now, you're going to be 70 years old with the continual on your back, in and out of custody. You're so messed up right now, you can barely open your eyes, man.
Your Honor.
And I don't know if you're enabling it or you're closing your eyes because of the love that you have as a father, but
He has severe ADHD and severe Tourette syndrome. And we put him in a recovery center, and we told them, we sent them the documentation. They told us every day they were getting the medication they ever did. Never did, until they finally refused to answer my phone calls because I kept calling them up what he needs to be on.
I said, this ADHD medicine robs him of his chemicals and his dopamine chemicals in his brain. And he goes, he uses drugs to put them back. And I said, the Tourette's makes him not make good decisions. It's not a good combination. And they said, yes, that's the case in almost many drug addicts with ADHD, and they wouldn't fix it, right? And so I got pretty upset with him because he got out and he had a pill bottle that he got the day he got out. They had never given him any pills the entire time he was there for these things. So I agree that it's a bad problem and a wrong problem, but I also agree it's not entirely his fault because he's got a chemical imbalance that nobody is addressing and never has. He's had this since he was a young child. They've addressed his Tourette's, but they've never addressed the ADHD. And I didn't know until I spoke to a doctor a week ago or a couple of weeks ago before he went into the rehab. And the doctor said, they said, so he's got he said he's got ADHD. And I said, yeah. And he says, does he have a problem with drugs? And I said, yeah. And he goes, why isn't he on Ritalin? And I go, what do you mean? He says, that's what Ritalin is for. And if he was speaking apparently from personal experience, so we tried to get him on Ritalin. They wouldn't do that because it's a substance itself. And they said that he could be abusing that substance. So we tried to get him on a secondary substance that's non-abusive. We had fought for weeks, months, and we can't. We finally got him a prescription just as he's now out and back in trouble. So I only beg that we don't want him on drugs, right? But we understand that maybe there's some underlying compassionate issues, right? And I mean, I'd like to be in, but that doesn't work.
And it pains me because I think that as a father and as a mother, due to love, a lot of times, and I don't know necessarily you, but people tend to kind of shut their eyes and become naive to the fact that they're using, and I'm not talking about marijuana. I'm talking about cocaine. I'm talking about meth.
Be careless. He's got a license for marijuana.
So regardless,
any heavy drugs, the cocaine or anything that's going to cause him a lifelong problem, no. I want him off of that stuff. But he's been in rehab 3 or 4 times. That doesn't really work. So I don't know what does work.
You gotta want it. One of the main things is you gotta want it. But be that as it may, he's trying to fool us, and it's unacceptable. And there has to be accountability for it. I can't just let him go when you're using a Whizzinator to try to fool us. It's unacceptable, and there has to be accountability. And the problem is that I think that what we need to do now is have him evaluated by our clinicians to see how we go forward. So what I'd like to do is, while he's in custody now, I can have it done in a very expedited manner. I can have it done within, today's what, Tuesday? We can hopefully have a report back by Friday to see, at the latest Monday, to see how we go forward. Our clinicians can talk to him, and if he's honest, figure a way to go about doing this. And I'm going to tell you now, while I have him here, I can pay everything for you, so you don't have to pay for a dime. If you're on the outside, though, I can't pay for it.
We can forward you doctor's records and things like that.
My only concern and the only thing I want now is our clinicians to be able to speak to him to see where we go forward. Mr. Terrell, I'm going to have you what's called TRAS to see, it's an evaluation to see where we go from here. If we get this TRAS back and it tells me that your little bunny's jumping in the woods and that there's no problems, then I know that you weren't honest, and I'm going to make you go do it right back again. And we're going to continue to do it until you're honest. But, you can lie to me, but you can't lie to yourself. You can't be like this forever. At some point, you're going to be a habitual and you're looking at 25 to life.
I forgot what it is. Thank you for your patience, but
you don't have to. And I'm really, truly sorry.
He did man up and come in. He wasn't going to. We had to fight with him and beg with him. He didn't.
To come in.
He didn't want to.
Of course. No one wants to go to jail.
And because he said, I said, he's not going to put you in jail. He goes, yes, he will. And I said, no, he has a heart. He's not going to put you in jail. He knows that you have a problem. The problem is an issue. not, I mean, stopping the thing that's causing this is the issue.
Your last name, Mr. Terrell?
Yes.
We've tried that. I gave him to you.
But he didn't, we tried it, but like I said, the underlying cause, which we've only just recently found, or
They've
found that
never
it may be,
treated the
they've never
symptoms.
treated.
I understand.
And
I
so here
understand.
he's untreated and still being treated like it's a normal case, and it's not really.
I tried. I've given him back to you guys. I've asked him repeatedly to stay sober and not use, and he continues to do so. No matter how many times I give him to you, it's
That's being
going
caused by something.
to continue, and you have to realize it. And if you think that just him saying, okay, I'm gonna stop, or the Ritalin is gonna make it stop,
As for many people.
it may have. And yes, it may have.
So how long are you putting him in for?
I don't know. For now, would like to have him TRAS to see where they go. My feeling is that they're probably going to say that he needs inpatient rehab,
He's already been, to.
not in the jail.
Yes, he has. You sentenced him to that last year. Why, Mac?
I don't have, we didn't put him in YMAC. Did we do YMAC with him?
But they never actually treated the symptoms either.
The
So we
probation
have other, if YMAC didn't work, we have other facilities that we can go to. And we've got at least 3 to 4 different facilities, and we can continue to put them into each facility until it takes.
He has this felony case that this case is associated with this next week. Yeah. Of which
So
we're
will they
hoping,
release
we're hoping gets thrown out of court.
They have also facilities as well to help treat as well. We both do. And we both have facilities. They have more resources than we do because there are more serious cases up there. So they have quite a bit of more resources.
It does look like he went to YMAC, but that's mainly to address like this attitudes and thinking. Now
It was for drugs because he was on probation for drugs. That's why he was.
No. What she's saying is that
The program that he went to was supposed to address like this thinking, attitudes and things. So now we're gonna assess him now that we know that he has mental health issues and as well as substance use problems. So,
His went last time because of substance abuse. That was what the story.
no, but she's saying no.
She said no, but this time.
Okay.
Well, I think, Judge, they might be referring to the deferred was adjudicated based off of drug violations. He tested positive for many times for drugs. That's why his guilt was adjudicated in that case in this court. I think that may be what they're referring to.
Yeah, it was because he was on probation for drugs. And they actually, yeah, put him in there. And then, when he came, he couldn't even get his lawyer when he came to court. He got a court-appointed lawyer when he had a lawyer who was paid for it. Twice. And it's very frustrating to us that he doesn't seem to be getting fair treatment. It seems like he's being held as an example and be given as an example and not being given fair treatment. And
How is he not being given fair treatment?
well,
Tell me.
I just really wanted, my wife is not gonna be happy if I.
Well, no, but it seems like you're blaming me for the situation,
No, sir. What we're trying to say that he never got an assessment for the mental issue.
And they were told over and over again. I wrote
They.
the court officials, the probation officers, everyone was told that he had these issues and problems. They did nothing about it. Okay, his attorney brought paperwork to the court, Mike Monk.
Yeah, because we gave him the paperwork with all the.
Nobody did anything about it. So we keep
So-
going, you guys keep blaming this stuff, but you just keep holding him up as an example and punishing him, and we never try to find out what's the problem.
Put people in jail when they violate conditions, when they do something against the law. We don't willy-nilly put people in jail for S and giggles. We don't do that here.
So why is
If
there?
someone has a true problem, then we give them the opportunity to try to do things on their own. When it becomes evident that they're unable to, that's when we try to step in. I don't do this out of hate.
Outside of he, we know that he has a problem, but outside of that, like he has a felony charge they aren't giving these bond requirements. And this misdemeanor court is giving these bond requirements, when the felony court is not. So.
Can't tell you what the felony court, I want to make sure that he's not using alcohol or drugs.
It has nothing to do with this case.
How do you know that?
Judge, there are facts in this case that do indicate that there were crack pipes recovered from the defendant. And that's most likely why.
How do you know that he's charged with a felony assault? He's charged with interference with emergency request for assistance. How do you know that the drugs and alcohol that are using did not impact this?
Because he was sound asleep. All right, and she stuck a machete through his TV. Okay, I know, we're not supposed to talk about it. I apologize.
Look,
It just feels very wrong.
I know that you see through the eyes of a loving father, and I'm not going to fault you for that. I get it, and I understand that. And I'm sorry, I really am. But I think that the best thing for him now is in a facility that he doesn't have access to drugs or alcohol. And I'm trying to do my best to keep him clean and sober. He tried to fool us now by using a Whizzinator.
That's why he didn't want to come in here. He would rather be run, that's why he didn't want to come back.
Okay, and you can't run forever, Mr. Terrell.
I know, I tell.
So it's better to man up and get it done now than to run forever and do some irreparable damage by taking something that you kill yourself, right? Because that's invariably what's going to happen. The dope that you're using, you're going to kill yourself. He can barely open his eyes, man. This boy,
I'm listening to everything you're saying, sir.
You're so high right now, you can barely open your eyes.
I'm not high at all, actually, I'm sober. So, I mean, you can, at this point, I'm already in handcuffs, so it really doesn't fucking matter what I say.
No, he's not. I know, we've been with him for 2 days.
And I'm going to ask you, just bear with me. I'm trying to do the best I can to keep him clean and sober, so he doesn't pick up new cases.
Got revoked his bond, is what he's asking.
Yes, I'm revoking his bond. I'm setting it at 20,004 right now. But if you bond him out, that's your choice. But I'm going to continue with the same things that I'm doing. And I'm now going to have him come twice a week to test with me. And the next time he tests positive, and I don't care what it is, the bond is going to end up even higher than it is. And at some point, we're going to address the issue. But I'm not going to continue to let you use drugs while you're out there in the free world. That's it. Huh? Yeah. Well, the first thing we have to do is we have to evaluate to see which one is the best one. They have mental health caseloads. They have the first thing that needs to happen is we have to have him evaluated, speak to a clinician. They can tell us which the best path to go forward. They may say he needs intensive outpatient treatment. They may say he needs SATF, which is an inpatient facility. I don't know until we have him evaluated. But understand, I like your son. I want the best for him. I really, truly, and he doesn't get it.
No, because we watched on TikTok him being in front of your court, and we're going, what the heck is that doing on TikTok?
I live stream all our proceedings, and that's what we do. So it adds transparency. So
I'm going to have to excuse myself. I'm not helping. I know.
I just cannot listen.
Look, you're not making us mad, and I understand how you feel, and I get the loving father. I wouldn't be in the same position as you, but I want to keep him clean and sober. That's the bottom line. I've tried to do it the other way. It's not happening, and he's fooling us. So the only recourse I have is this. So if we can set it to your ASAP, hopefully we can have the report back by Friday.
Monica, how do you really feel?
At the latest Monday, they will tell us which is the correct course to go, and then we can all sit and talk and decide what to do. At the end of the day, if you want me to just do nothing and
I'd rather you help him.
If you want me to let him go and just fend for himself, then it's on you. But know this is that what you guys are doing now, it's not working. He's slowly killing himself, as evidenced by his demeanor, the way he looks. He's killing himself slowly. And before long, he's going to really deteriorate.
He is so high right now.
I've seen it happen all too
I
much.
can almost feel it.
All right.
And Judge, before we end this conversation with this defendant, I've spoken at pretrial about the records that they have about the defendant and what he did.
Hold on, Michael, before you say anything else, hold on. Guys, you can always count on Michael to just one more sucker punch before it's over. You know what? This all happened. Judge gets everything calmed down. We're about to end. And then here comes Michael. He's going to knock everybody out.
Did today. I'd like to obtain those records and get those provided to defense counsel as well and provide that to felony. They're willing to provide that to me upon your oral consent to that. Okay, pretrial, do you hear that? Okay, great. Thank you, Judge.
So getting him in more trouble.
No one's in more trouble. I mean, do you not see what I'm trying to do? If we wanted to put him in more trouble, we charge him with additional offenses.
Isn't that what he's trying to do?
No, no one is, we're not here to punish and enslave and to kill. We're here to help. And sometimes that may require this. Out there, it's not working.
I have your word that it's not going to come back.
No, I don't make the charging decisions. I'm not going to give you any kind of word. I'm going to give you my word that I'm going to try to help him as much as I can. But I need your help with that as well. I need your help with that as well. Look, I don't want to have any discussions until with the case, with anything as well. Hold on a second. Hold on. Wait a second. Hold on. Just about giving the records to Mr. Haddad. Hold on a second. Until he talks to his lawyer, we shouldn't talk about the case at all. My only concern now is being clean and sober. That's my only concern at this point. Okay? So we're going to take him back. We'll have him TRAS as soon as possible. We can set it for Friday. Hopefully we can have the records back by then as far as what the thing is. And we'll go from there. Okay?
Do you want me to get rid of all the other Michaels?
Judge.
Yasha.
Yeah,
What
when can I come back to follow up on this matter? Can I come back tomorrow?
When can we have him TRAS?
Monday, because he has to be processed today. So, give me
Monday.
Wait,
I can see if somebody can come to hold over.
What day you say?
I'm just trying to keep this stuff out of evidence. So
And so let's say we take him in now, he gets processed today, he's in POP tomorrow.
Not talking from.
It
You're
doesn't
this is
involve
live
it.
stream, you're
It's
talking
involved in
about
this.
part of the
Let's do
case.
Let's do Tuesday, just to be safe and have the report.
Next Tuesday.
If it's back sooner,
Oh, you mean for the report to be back? Oh, okay. But I'm talking the actual evaluation. When do you think? Maybe Wednesday?
I said it before and I'll say it again. This channel is only about education.
Friday.
it has to be processed. I don't know how long it's gonna take.
Private issue.
Okay, all right. Okay. I'm gonna try to have him evaluated as quick as possible. Hopefully we can have it done by Friday and the report back by Monday or Tuesday, okay?
For the record, for anybody in Judge Fleischer's chat, you can't type Wizinator. You can't type that because we're just going to have to keep deleting it and over and over and over and over and over again. Y'all keep traumatizing us. Squeaky clean. Can you guys just keep it squeaky clean, please? Talk in Discord.
I'm gonna put him back now. So Yasha, if you'd like, we'll have you call the holdover so you can talk to Mr. Terrell now. Is there anything else you wanted to add?
Judge, I confirm whatever Mr. Terrell just said, about the fact that he needs help. He needs to use his medication. I believe that if he does start using the medication, it will help his situation. I don't think jail time or incarceration is the solution. I really think that he needs help with his medication and some sort of rehab to get out of the situation he is in right now. I am actively working on both cases, the misdemeanor and the felony. I have provided some evidence to the felony prosecutors about the situation. And I'll keep checking back with them. If I have to go every day, I will.
Okay, and I trust that you will, Yasha, but unfortunately, due to him bringing a Whizzinator into the drug testing room to try to, fool us, it's unacceptable. And I'm gonna revoke his bond because of it. We're gonna keep him. We'll try to have him, TRAS as quick as possible to see how we go forward.
Yes, and let's
and-
get him TRAS, and then I will look at the report and I will discuss it with him and his family, okay?
Look, at a minimum, the TRAS will tell us which way they
are seriously killing his buzz. It's just rude.
believe is the best course of action. I will leave it to you guys to decide whether you want to do it or not. If you don't want to do it, if you just want to, let him out and fend for himself, it's up to you guys. I will offer my services to you for free. If you want it, it's available to you. If you don't want it, then it's on you guys. Okay?
Bills.
Let's not talk about everything now. Let's just see for me.
Judge, did you say?
So, Monday. Today we have a trial. So that'll be fun, right? Hopefully it's a good trial. Yes, we're going to see part of the jury. Yes, we are. Just relax. Just relax. It's fine. Okay? We're not going to be able to see the TVs. I don't even know if the TVs are working yet. And look, they moved it so that it's pointing towards the gallery. So we're not going to be able to see the TVs. Hopefully we can hear them. That's all I hope for. Can we please just hear the people talk? And no staplers and stamps the whole time. Ramona's going to have to earn her paycheck today. She's going to have to take down all this, get it transcribed. I don't know. I feel like sending her a cupcake or something to help her get through it. Hopefully she can hear them. It's not important to see the jury, but if we see the jury, people in chat go nuts. Like we've punched their dog in the face or something. We see the jury. If you walk into that courtroom, you can see the jury. So, yeah, box of cupcakes maybe. Or trial won't happen. Trials don't happen all the time. We could wait. It's 7:30. So like in 2 hours, we could walk in there. There's no trial. It'll be a real light docket. And we get to take a nap before work tonight. Or it's a very long trial. And I'm almost late for work today. Yep, they could plea. I don't think he takes pleas on days of trial, though. Yes, I hear 3 boxes of cupcakes calling my name right now. No, cupcakes are not my favorite, not at all, because they're just so I like to easily eat my food, and the icing gets everywhere, and no, they're not my favorite. I did like, was it Anna Kendrick who ripped the bottom off? Oh no, it was Anne Hathaway. Who was it? She like unpeeled her cupcake, ripped the bottom off, and made it a little sandwich, and I thought that's awesome. Now I can eat a cupcake. Only when you bite it, the icing squirts out. I just like things that are easier to eat. Yeah, Anne Hathaway, that's who it was. That's exactly who it was. She is classy. Anne Hathaway is top-notch classy. She is. She's like, oh, sugar. Breakfast at Tiffany's girl. Help me, help me, help me. She's very, very famous. Who is she? I can see her. Who was the girl in breakfast at Tiffany's? Natalie Polly. Was it Audrey Hepburn? Yes, she is classy. Her and Anne Hathaway. Total class. 100% class. We had trivia last night and for the picture round, so there's 4 rounds. 3 of them, he just, asks the questions and you write down the answers. But the third round, never mind. One of the rounds is a picture round where he hands out a piece of paper with all these pictures on it, and you have to fill them in. And it was every celebrity in Madonna's song En Vogue. So I know the song, so I had a lot of the names right, but they are just too old for me. So they were all in the wrong place. They were all in the wrong place. I got I got a lot of the names. I got a lot more names than anybody else, but I got a lot off because they were just in the wrong picture. And it hurt my feelings because, I knew the song, just didn't know what these people looked like. That was way before my time, most of them. I got Joe DiMaggio though. Yeah, I did. Yes, I did. Got Marilyn Monroe, but it was fun. It wasn't fun. Last night was not fun. I hate the crowd on Tuesdays. They are so mean. They are just mean people. We have this one guy that comes in, Michael, and I was like begging him to stay with me. Please don't leave me here with these people. But he said the words that made me stop. He says, I can't stay because I can't drink too much. Someone says that to me, that's it. That's enough for me. I won't offer them any more drinks. If they ask me to pour them one, I'll try to talk them out of it. So he's like, "No, I can't drink too much today." Okay, here's your check. Thanks for coming in. Bye. Leave me alone with all these bad people. CJ, they don't care if I speak English or not. I'm telling you, I have trays full of dishes in this hand, dishes in this hand, trying to get it back, and they're behind me, tapping on my back. Can I have a beer? Can I have a beer? Bitch, I was just at your table. Why didn't you tell me that a second ago? They are serious. It's not even funny. There's no prize. You get your picture on Facebook for the trivia guy at the end. There's no prize other than that picture on Facebook. And they are like dead, dead, dead serious. We got one guy though, Dave. He wins the majority of the time. He doesn't always win, but he wins the most. And he's just a team of himself. Just him. The rest of the rest of the dining room is like teams of 14 and 7 and 6 and 4, and there's him all by himself beating them all week after week after week. I can't, Carolyn, my mouth doesn't do that. I try. You don't understand. My mouth does not do that. My daughter is so good with accents, and I just suck at it. I can't do accents. Can't do Russian. Oh, darn. I learned how to swear in Russian and I forget it already. I wrote it down too. Russian, I don't know how to swear in, and that makes me sad. But I learned the other night, and then I forget. I was gonna show you guys, but I forget it now. You guys probably already know how to swear in Russian. You guys are smart. No, not on Tuesdays. Tuesdays, no one tips. I, I I love nurses. I respect nurses so much. I mean, without nurses, I don't even know, there's no words to describe how much I respect nurses and what they do. But when they walk into my bar, I just want to cry because they want the extras and then they never tip ever, ever. Maybe if the trial lasts long. Yeah, but you know what? They'll save my life tomorrow, so it's fine. If I had a heart attack, they're gonna get me. So it's fine. Don't worry about tipping. Don't worry about it. Don't worry about it. I feel safe when nurses are in the bar though, because if I fell down and had a seizure, they got me. If I was choking, Heimlich away. I was always taught to tip. What strike two? Sorry, I have a 12-year-old sense of humor sometimes. All right, I'm gonna see you guys in 2 hours or so. I knew it. I knew Fozzie was gonna come in with just a tip, and he did. I'm gonna see you guys in 2 hours at the at the trial. I'm gonna play the trial tomorrow if it happens. Who knows? Oh, Tokyo's here. We gotta go. Bye. Hi, Tokyo. Do you have a show today, Tokyo? Bye, Carolyn. All right, all right, all right. Where's my outro? If Tokyo has a show today, go watch it, guys. Dun, 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 dun.
Got these lights that close digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes mirror sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm.